So thank you for joining, everyone. So just bear with us a bit. Oh, so most people can't hear you anyway. Thanks for joining, everyone. We're just sort of getting everything, admitting everyone and getting everything set up. So yeah, most of you are going to be put on mute and your videos turned off, so except for the speakers. So just bear with us a second while Tom is setting that up. Okay, so yeah, we're just giving it another minute or two. Just to give everyone a chance to sign in, and then we'll get started. Okay, so let's get started. So I'd like to start off by acknowledging the traditional owners of the land on which the University of Sydney stands. So I'd like to say that we acknowledge the tradition of custodianship and law of the country on which the University of Sydney campuses stand, and we pay our respects to those who have cared and continue to care for our country. So welcome to our first Journal Club webinar of 2021. So I just got to get the year right. So today we will be talking about clinical record keeping. So it's a very practical topic that we're discussing today. I will introduce our speakers, Shayla Gooley and Dragan Gasic, in a moment. But just like to start off with some housekeeping. So most of you in the session are going to be on mute and your video is hidden. If you would like to ask a question of either myself or any of our panelists, please use the chat function down the bottom. So please address your questions either to everyone or to me, and then I can then ask our panel some of the questions. Now, I may not get time to address all of the questions that people ask, so apologies in advance if I don't get to the question that you ask. But if there isn't time for your question, feel free to email me later on, and I can either respond or ask one of our panelists to respond later on. Okay, so I would like then to start by introducing our two panelists today. So first of all, we have Shayla Gooley. So Shayla is a clinical psychologist, and she is the director of the University of Sydney Psychology Clinic. We were just sort of joking around the other day that we couldn't remember how long exactly when she'd been here for, because we've been working sort of along the same corridor for a few years now, but so it was around 2007, I think we sort of arrived at, was it Shayla? Oh, sorry. Yeah.
2017.
2017. Yeah, so she has extensive experience working with children and families, but as the director of the clinic, she obviously is involved in training new psychologists on professional practice, and she's going to be talking today on clinical record keeping. And then we have Dragan Gasic, who is a senior solicitor with Wesley Mission Community Legal Service. He specializes in civil law, namely litigation, advice, and advocacy. His areas of specialty are family law, corporate and commercial law, personal insolvency, money claims in the New South Wales Local Court, District Court, Supreme Court, and tribunal work. And he has over 20 years experience in litigation, including 8 years in practice as a Sydney-based barrister. Unfortunately, his video decided it didn't want to work this morning, so he is joining us by phone. But welcome, Dragan.
Thank you.
So, all right. So we might get started with Shayla. So Shayla was going to give a brief presentation on general principles of clinical record keeping, after which Dragan's going to give an introductory speech on legal aspects of clinical record keeping. And dealing with courts' requests for information. And then after that, we'll open up for questions to both of our panelists. So over to you, Shayla.
Thank you. Welcome, everybody. The sort of guideline that I was operating on was really, it was meant to be less on formal slides and lecturing, but enough to lay some principles, make it pretty practical, and then leave over to interaction and questioning. So I've only got a very few slides, and so I tried to distill what is a complex area. What I realised was that when there are really two main things, because I was anticipating what kind of questions might come up. And the two things that came to mind was my hunch is there'll be very few questions that can be answered yes or no. And that's just the world in which we work. You know, clinical work is really around the idea of ethical dilemmas. And a dilemma, by definition, doesn't actually have a yes or a no. And the other thing that came to my mind was when someone comes with a question, you know, a dilemma, an ethical dilemma around record keeping, the response usually, whether it's a response from a colleague or a supervisor or someone senior that you might work with, should actually be, well, it depends. And then that gets, you know, the wheels in motion in terms of what am I recording, why am I recording it, etc. So anyway, I just wanted to sort of say that as a bit of a opening statement. Oh, I don't know why my thing's not moving. Oh, there we go. Okay, so sorry. The first the 3 points actually that I wanted to make is when we think about clinical record keeping, it isn't one size fits all. It really will depend on our work context, and by work I mean in relation to the organisation that we work for, because there will be organisational parameters that guide, you know, what we write, who does the record belong to, how will the record be used, etc. So we do need to keep that in mind. We then need to keep in mind the clinical context. I think the clinical context, again, will influence who does the record belong to and what do we need to be recording and why are we using it. And then the third thing really is whenever we come up against a dilemma, I think the first step always has to be seek supervision. because if it is a dilemma, it's unlikely that it can be easily solved all by yourself. And I suppose I've got my director hat on because I'm training new psychologists, and supervision is such a regular and integral part of what we do. Okay, but there are some principles. It's not like it's so vague that we can't be guided by some important principles. So when we think about clinical record keeping, what I did was I extracted 4 principles, 3 on this slide and 1 coming. These principles are from the Code of Ethics. It was originally developed by the APS, but has actually been taken up by the psychology board. So this is the code that we would be referring to guide our practice. Probably important to say that this code exists in its own right, but sits alongside any organisational work parameters and clinical context as well. So the first principle is really the principle around respecting the rights and dignity of people and peoples. That's the first general principle in the code. And the 3 aspects of that principle, the first one is informed consent. So when we write a record, I just need to move the little thing here. When we write a record, we need to keep in mind informed consent. So we need to provide clear and accurate information to the client, the patient, about what is being done with them and for them and with their personal material, and that they give their consent for that to occur. So in our informed consent discussion that we have, somewhere in there, we're going to be talking about the fact that we will keep notes and records, because that's the only way we can demonstrate that we've provided a service to that person. But what we include in there really then touches on the next point of privacy, well, next to privacy and confidentiality. Whatever we collect has to be relevant to the service being provided. We don't just write anything and everything. Now, this is what's quite interesting, because in our session, I'm thinking about clinical assessment and treatment. Anything and everything may very well come up. Our responsibility is that we're not just probing and curious for the sake of it. It really is connected to why that person has come in, and that any information that we collect is going to inform any clinical opinion we might have and any treatment that we provide. But the person sitting in front of us, they may very well tell us anything and everything, or not anything at all. So constantly we're thinking about clinical relevance and protecting privacy as well as confidentiality, which is the next point. So confidentiality is that all information is safeguarded and is protected. And when people understand that we, because of their right and dignity for privacy and confidentiality, understand that that's the care that we take, I think that, is reassuring to them that this is very protected information. And then the final one is the ethic around the release of information. So obviously we have permission to consult if we need collateral information, but the other thing that points to is that a person does have the right to access their records. And it's a very straightforward line when it's the person themselves requesting access to their own record. It becomes more of a dilemma when it's a second or third party request, but a person is allowed to access their records. The implication there is we need to think very carefully about what we're recording and how we're recording it. Obviously, Dragan knows way more about this than I do, but that there is the Government Information Act of 2009 that guides how someone applies to access their own records. In a university setting, we are just so buffered and cushioned beautifully, because whenever there's a request for accessing records, my first step is to liaise with our Office of General Counsel and legal people, and they guide that process. But I just put that's important to keep in mind, because that actually does touch on what are we recording and how are we recording it. So the next couple of slides is really, really practical. This comes from the New South Wales Psychology Council, who put out newsletters on all sorts of things, but they put out a newsletter on what do we actually want to, how do we actually structure a clinical record? I've been using this as a way of helping me supervise and teach new psychologists that are coming through. And since having done it, the notes have actually become a lot better. So in terms of an initial, and this might be well known to, you all out there, but I thought it's useful, practical information. So in terms of following an initial assessment, what headings can I use when I'm writing that clinical record or that progress note of that initial assessment session? And really, this is what I'm wanting to, hopefully this is what I've inquired about. And so these are the headings that I'd be writing under. So the referrer and the reason for referral, the presenting problem, either as stated by the referrer or expressed by the person who's coming in. Obviously, there might be collateral there. It may be a family member who was actually the person who instigated the process. Presenting problem, the history of that problem, any previous treatment and response to treatment, some psychosocial history. This gets interesting because this touches on that point of privacy. Do I want to know every single little thing about that person's life, or what aspects of the psychosocial history is important for me to know to understand the presenting problem and the history of that problem, and that might be very important in terms of informing treatment. Results of any formal assessments, including previous diagnoses. That will touch on any other health professionals or any other people that might have been involved, and so then I need consent to access that information. And then I'm thinking about privacy. What assessments do I want to know about, and why would that be relevant? And the next heading is after an initial assessment, I'm probably starting that process of formulating, trying to understand what's going on and why might it be happening, and then what my plan will be for anything following any subsequent sessions. Then there are a list of headings for those subsequent sessions, and typically this usually follows a feedback session I might have with the person, where I talk about, look, this is my understanding of what's going on. This kind of is what I'm thinking about in terms of why it might be happening, and this is my thoughts about what we can do about it. Now, it's obviously meant to be quite collaborative. It's not just me dictating what needs to happen. So the notes thereafter really just follow these pretty standard headings, which is, well, who was present at the session? Students are particular about writing that they were present, but we take that as read. So you don't actually have to write that you were present, because you were there and you're the one writing the note. There's usually a heading around agenda, like what are we going to be covering in today's session? What was provided, so what was the type of service that was delivered in that session? Your this is you. What are your impressions of how that person presented in that session? Sort of a mental status, clinical impression heading and comment. Reviewing what did occur in the previous session, what was provided in this session, and what's going to be done in a subsequent, in the next session. So they're the headings that can guide subsequent progress notes. And this is now what we need to keep in mind. So with all of that information about structuring and headings and keeping in mind those ethical principles, we've really got to keep in mind some of these points. So we do need to have a record, otherwise, how do you know that anything's happened? And it needs to be a quality record. So a record has to happen. And it's got to be pretty reasonably formal in terms of the language that's used and the, obviously, as I said, the headings, etc. It shouldn't be a transcription per se. Like everything in that record shouldn't really be he said, she said. I mean, there are exceptions to that, but it's not a straight out transcription. It's a composition and a synthesis of what happened in that session. It needs to be accurate. You don't want to compromise accuracy, but because you're trying to preserve the privacy and the dignity of that person, it can't simply be a transcription. The language has to be moderated. It needs to be accurate. So there are a few things going on there. But I think that they're important things to keep in mind. And that's the final thing. So that's all very general. Maybe when questions come up, we can come up with some more real life examples, but that's all I had to say. So that's it. I'll stop sharing.
All right, thank you for that, Shayla. And yeah, so they're the general principles. And if anyone has specific questions and or any sort of specific dilemmas that they've encountered in this sort of area, please feel free to send through a question using the chat function. And I will take our questions to the panel once after we hear from Dragan speaking. But thank you for that, Shayla. Oh yes, so I've just been asked if we're going to get a copy of the slides, and yes, we will have copies of the slides. If Shayla's okay with that, we will provide the slides to everyone. All right, so I am going to throw over to Dragan. As I said, unfortunately, he is via phone today. But yeah, he is going to speak on more of the legal aspects of when our notes may or may not be involved in the court process. So over to you, Dragan.
Thank you, Chris, and thank you, listeners. I'm going to focus on two legal areas, which is production of documents under subpoena, and I'll touch on broadly with confidentiality and admissibility. And I'll use examples from the family law jurisdiction because that seems to be the jurisdiction that most counsellors encounter during the document. So I have got slides available, but obviously I couldn't present them today. If anyone would like copies, I'm more than happy to provide them to you. Just let Chris know and I'll forward them on to you. Now, subpoenas. I mean, what is a subpoena? A subpoena is an order from a court requiring the addressee to produce to a court a copy of the subpoena and the documents or things as directed by that subpoena. Alternatively, you can attend court to give evidence as directed by subpoena or to do both. So when a subpoena to attend and give evidence means that the person to whom the subpoena is addressed is required to attend court and give oral evidence. Subpoena to produce means that the person to whom the subpoena is addressed is required to produce those documents of all things that are set out in the schedule to a subpoena. And when you're asked to do both, you're asked to produce documents and also provide evidence. And when you do provide oral evidence, you can be cross-examined on that material. So when you receive a subpoena, don't ignore it. Make sure that you look at the document and find what the return date is. You should diarise that and then bring the subpoena to the notice of your superiors so that the appropriate people can attend to collating that information. Now, if time is an issue and you may have documents off-site, then you can ask the court to negotiate an extension of time. The failure to comply is a very serious matter. So it's very important that the subpoena that you give the subpoena the due respect that it demands. Now, a question is how does the addressee determine the scope of the subpoena? The schedule to the subpoena will give you an indication of what documents are being sought. So you must read the subpoena very carefully to determine the scope of the document. Documents that do not come within the scope should be removed from the client record before it's copied and documents are sent to court. That would also mean redacting portions of the document if they're extraneous, irrelevant, or privileged information contained within that document. Now, I'll use an example of the scope of subpoena, and this is a fictitious example. Say a patient, and her name's Susan, attends Blacktown Hospital on the 28th of January 2020 after being sexually assaulted. On the 30th of January, she visits a service in relation to a government service or counselling service in relation to the sexual assault. And there are several sessions with the sexual assault counsellor. We'll call her Jenny. So some months later, the defence in a criminal trial decide to issue a subpoena on this government service or a counselling service to have access to documents held on Susan. So some of the requests include all notes relating to the visit by Susan to the service on the 28th of January 2020. Now, the service wouldn't hold any records relating to this session because Susan saw a hospital and not the counselling service. So you would not be required or expected to volunteer any information to the other visits that Susan may have had. Another paragraph in the subpoena may sound like this: all notes of the visit by Susan to the ACS or to the service on the 30th of January. The only records caught by the subpoena are the actual notes which relate to the visit on the 30th of January. No reference is made to any other visits to the service, so these documents are not caught by the subpoena. So it's only the documents on the 30th of January. Another request may sound like this: all notes and counselling records prepared by a counsellor, Mary, in relation to any counselling sessions conducted with Susan. Now, the subpoena names a specific counsellor and only requests her notes. Now, as Mary didn't see Susan, any records covered by that subpoena is not required to be produced. The service is not obliged to inform the court that another counsellor saw Susan. Now, this one is the more standard schedule request. Any records, notes, reports, or any other written material held by any facility of the government or the counselling service relating to Susan and dealing with an alleged sexual assault on the 28th of January. Now, this is the more usual approach. So the terms of the subpoena are broad and clearly capture all of the relevant documents held by the counselling service on Susan. So it's important, very important, to make sure that the subpoena is addressed to the correct legal entity of the counselling providers or the government department. And arguments could be raised against complying with it. So that's a question of judgment. And if you encounter something like that, it'd be a good idea to speak to an in-house legal person or contact us. We'll be more than happy to help you out with that. Now the question becomes, what documents need to be produced? Now that depends on the scope of the subpoena. It's set out in the schedule. The definition of document is very broad. It covers most electronic texts, emails, documents, faxes. So it's a very broad, all-capturing definition. Now, when you get the subpoena and you determine that there may be grounds to object on the question of confidentiality, and I'll touch on that issue just a little bit later, but in most instances, when a subpoena to produce is issued, the issuing party must also serve a copy on all the active parties to the proceedings. So, it may, on the application of a party to the proceedings, or the government service or the counselling centre, or any person having sufficient interest in setting aside the subpoena, you can do that, and a date will be set aside where you can raise those objections. And you can also do it by way of keeping the privileged communications in a separate bundle to the main bundle. So if there are confidential or sensitive issues, you would segregate them from the main body of the documents. And the court will then decide what to do, whether or not to release those documents. So as far as you're concerned, you discharge your obligations and your professional duties, and then becomes a matter for the court to determine whether or not those documents are relevant and admissible. Now, if a subpoena is too wide or too oppressive, which means that if you're required to make a judgment on the information, or if information is kept off-site and it's too onerous and oppressive to comply, you can make an application to the court to discharge you from that obligation, or to provide you with that extra time to find those documents. And if costs are involved, you're entitled to claim your costs in reasonably complying with the subpoena. Now, records relating to the counselling of victims of sexual assault, it's a protected confidence and may be protected from the production if they are covered by the sexual assault communications privilege. They can be claimed in criminal proceedings, including proceedings relating to AVOs in New South Wales courts. The privilege may also be claimed in the federal courts, such as the Family Court, Federal Circuit Court, if exercising jurisdiction in New South Wales. Very broad category of communications privilege. We also have the professional confidential relationship privilege. This applies to communications made by a person in confidence to another in the course of a relationship in which the confidant was acting in a professional capacity, and where the confidant was under an express or implied obligation not to disclose the contents of the communication. So this provides a segue into discussions on confidentiality and inadmissibility of communications. Now, in the family law context, you have Section 10B of the Family Law Act, which sets out the circumstances in which the communications made in family counselling must and may be disclosed. So family counsellors must not disclose a communication in family counselling unless the disclosure is required or authorised under the Act. So if you receive a subpoena and you feel you need to claim confidentiality and privilege over those documents, you can do so by putting them in a separate envelope marked confidential. Family counsellor must disclose the communication made in family counselling if he or she reasonably believes the disclosure is necessary for the purpose of complying with the law or mandatory disclosure of suspected child abuse. Now, the family counsellor may disclose the following if he or she reasonably believes that the disclosure is necessary for the purpose of protecting a child from the risk of physical or psychological harm, preventing or lessening a serious and imminent threat to the life and health of the person, reporting the commission or preventing the likely commission of an offence of violence, preventing or lessening a serious and imminent threat to the property of the person, reporting on the commission or preventing the likely commission of an offence in relation to person or property, and also assisting an independent children's lawyer to properly represent a child's interests. Now, you may wonder, well, when do we need to disclose this? Are we required to disclose this to the people that we are seeing? In short, it would be very wise if your onboarding documents would have a statement to the effect that I've just set out to cover you professionally in terms of disclosure. Now, there is an interesting court case which deals with how evidence it can be used in family law proceedings. Now, there's a case called Choate and Grandel, where there were contested parenting proceedings relating to the child who was 12 years of age. There were allegations of parental alienation as well as family violence against the father. Now, the independent children's lawyer issued a subpoena to the model clinical psychologist for her counselling notes. Now, the father sought to inspect the records on the basis that he believed would be relevant to the mother's mental state. Now, the mother objected to the release of the subpoenaed documents on two grounds: that the communications with the psychologist were confidential, and that the details of the trauma suffered by members of her family, incidents that occurred in high school and residential address, telephone number, were irrelevant and inadmissible as evidence. Now, despite the family court finding that the documents were confidential, that did not mean that they were not relevant or inadmissible. Now, how that's relevant to your practice means that it's not for you to decide what's admissible or not. That's a matter for the court. If there's an issue of confidentiality, you segregate those documents and you let the court decide whether or not it's admissible or not. But you would be claiming confidentiality over those documents. Your job is not to make judgments on whether or not these documents are relevant for the purposes of the court case. That's a job between the solicitors and the judge. So the court in this case accepted that the psychiatric patient-client relationship but would not attract a public interest immunity, but referred to cases where the judge held that the mother's counselling notes should not be excluded from the proceeding simply because they were of a confidential nature. As if those documents go to the mother's ability to provide parenting, that would be relevant to the issue in question. If it's about contact, or if the court case is about with whom shall the child live. Now, any document that goes to the fact of parenting capacity and ability, then those would be relevant. So, even so, if there are other issues in the case that are relevant, they may also open up those documents to be admitted into court of evidence. So, this case provides that information being legally confidential will not suffice in protecting it from being exposed in family law proceedings. So that's all I have to say for the moment. If you do want a copy of my slides, they're quite comprehensive, so let Chris know and I'll forward those on to you. Thank you.
Thank you, Dragan. And yeah, so anyone that wants copies, I've got a few people sending things on the chat, but if you want copies of the slides, it's best to send me via email, just because with the chat, I don't know the emails of people contacting me. So if you do want them, email me rather than contact me on the chat. But please do use the chat function to send questions for either of our panelists. And yeah, thank you, Dragan. For, I guess what really struck me from listening to you speak then is that I guess one of the key principles, I guess, that you're trying to stress here is that what is relevant and admissible and not isn't really a decision that us as clinicians should be making. And I think, as Shayla noted earlier, like, we are very lucky in the university space that we have an Office of General Counsel, so the university employed lawyers who essentially sort through these sort of issues for us when we do have subpoenas come up, which in a gambling clinic, as I'm sure, you know, a lot of the counsellors who have worked in gambling for a while are aware that these things do come up probably more regularly than what they would in other work environments, that we are lucky to be able to send them to our lawyers. I know a lot of you are working in organizations that probably do have legal teams as well. So probably with a lot of these questions that Dragan is raising, I think, yeah, being aware of your responsibilities, but also, you know, if you do ever have questions regarding the release of information, if you can seek legal advice, if you can't, you know, ask someone who might be able to advise you on what to and not to do. So do you mind if I ask you a question, Dragan? So with that, if you do get a subpoena and say you're someone that's working in a place where, say, you don't have access to legal advice, are you able to contact the court to clarify what your obligations are?
Well, ordinarily the court doesn't give legal advice.
Mm-hmm.
So a court would be hesitant in giving you advice about a schedule to a subpoena that they're not aware of. So it's unlikely that you would get that assistance.
Yep.
So you to err on the side of caution, you should write to the court that either the terms of the subpoena is onerous, I don't understand, for example, Schedule 2, that needs to be clarified. You can seek the court to direct the issuing party to make the subpoena more clearer for you.
Okay, thank you.
Yeah, sorry.
Sorry, go on.
No. It's like, sorry.
So, okay. And just also to clarify, so you mentioned a few examples of where people wouldn't be required to release information. So for example, if we got a subpoena that personally named me, for example, but the client saw a different counsellor here, you noted that would be a case where we wouldn't be obliged to release information. So in those cases, do you need to write to the court to say we don't have anything under that subpoena, or
no? That's not your job. Mm-hmm. Your job is to respond to the precise nature of the schedule to the subpoena.
Yep.
If it names you incorrectly and there's no documents, then you produce no documents.
Okay. So, okay. All right. So I did get a question for Shayla, and it was just, I guess, a practical question. So with regards to the length of notes that you include in a session, so what would be a typical maximum, minimum for both an assessment session and an ongoing session?
I know. So that comes back to that very first point I made, which is it depends. But obviously that's a very unsatisfactory response. It does depend. There isn't actually any length limit, really, because your note just needs to capture accurately what transpired in the session. But having said that, it's almost like, well, are there some rules of thumb? And what I would say is, what I have noticed, what I've observed in terms of my role here, is once I introduced those headings, the structure of the notes actually improved. And because people, when you've got a heading, you just respond, you just write down what's related to that heading. And because of that, notes have actually become less rambling and less lengthy. So usually in probably about, a couple of paragraphs, it seems like that captures a typical session. That might be a little bit of a rule of thumb. My few other observations are risk situations are likely to be a little bit longer because they are probably the kind of situation where you really do want to capture exactly what you asked and how a person, what a person said in response to that. So they might be a little bit longer. There are some other pointers that I probably should have had in the slides, but slipped my mind, like really practical things like, as much as possible, you want to stay close to what's being discussed. What I mean by that is you want to, as the clinician, if you are going to interpret, you have to make it clear that this is your interpretation of what the person said, or this is your observation. And then you have to make it clear as to what that is based on. The other thing is you always have to make clear who said what. You do need to attribute source. So for instance, like this is such a basic example, but it comes up all the time. Even if you wrote something like, Mary was stressed. Well, did Mary say she was stressed? Did you think Mary was stressed? If you thought Mary was stressed, then you need to say, I observed that she was. If Mary said that she was stressed, stress needs to go in inverted commas. Then you might elaborate on what exactly did she mean. And another example, which comes up all the time, and it usually comes up in terms of psychosocial history, is where the note will say, Mary talked about her mother having postnatal depression. Or Mary talked about, her mum having alcohol problems. It's like, well, how did Mary know that? And some of that information needs to be in your note. And that actually goes back to the way in which you conduct the assessment. So I can pop that in a slide, just extra little pointers, but these are things that come up all the time. So anyway, that's my response. I added a little bit extra.
Yeah, no, and I think that's also something that I talk about with my students as well, that it's really important when you're writing case notes that you write it in language such as, X reported that, blah, 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 rather than things that they're reporting to you, writing them as if they're facts, if you haven't observed them yourself. So it's really important to sort of be very clear in your notes exactly what happened and who's saying what, so that it's you're not sort of, I guess, stating something which you can't know even as well as that. All right, so I just wanted to let everyone know in regards to those questions around subpoenas, Jodie Rollinson from Wesley Community Legal Service has mentioned that if you are unsure about a subpoena and you don't have access to legal advice where you work, that you can, for gambling counsellors, you can contact the Wesley Community Legal Service for assistance with subpoenas. So thank you for pointing that out, Jodie, and I'm sure that's going to be a great help to a lot of people. Another question, I guess, for Shayla, and this is something that has come up with me before. So I was working with a client who was involved with a child custody issue. So she was, I think at that time, they were facts. There's something, what are they now? Department of Communities and Justice, or anyway, I've been working for long enough that they've had about 4 different names and acronyms since I've been working. But she was involved with a child custody issue, and she would often come in and, knowing that her notes had been subpoenaed, or there'd been various requests from what was then facts for notes, she would often report, oh, I've been gambling, but can you not put that in the notes because I don't want facts to know that. So when something, obviously the fact that she'd been gambling is highly clinically relevant for someone that's coming to a gambling counselling service. But given that she told me that she didn't want that in the notes, what rights do clients have with regards to something which is clearly clinically relevant to her treatment, but she's asked for me not to put in the notes?
My response kind of links back to something that Dragan said, which comes under that heading of confidentiality and limits to confidentiality. It's that idea of what is the risk for her, for the treatment, for the child in not reporting. Is probably the way I would be. I mean, even before I put pen to paper, I think it's the discussion that you have with the client in the first place, really. So that's the way I'd be thinking about it, Chris. It's not a straightforward answer, but I'd be thinking about what are the implications if I don't record this? I mean, straight away, informed consent, the very first thing we talk about with our patients is there is confidentiality, and then there's limits to confidentiality. We don't often think about that in terms of what we're going to write down, but I think that there is a connection with that. We often talk about limits of confidentiality in terms of who might I need to report to, but I think it does have bearings on what we record. The record isn't just, it belongs to the client, but it also belongs to us in terms of our responsibility as to why we're keeping notes in the first place. That's how I'd be thinking about it. And in the end, that's what I'd base my decision on.
All right, and I think, thank you for that. And I think it does highlight the point that you made earlier on, that with these sort of questions, there's very rarely going to be a yes or no answer, but it's something that you have to be, I guess, clear about the principles that that you're working under, because that's what's really going to help you answer these questions. Yeah. So, all right. So I've just got another question for Dragan as well. So with regards to the release of information, so you specifically spoke about subpoenas. Now, also something else that's come up for me in various other in moments for me is that I've got requests from that haven't come directly from a court, but have come from, as I said, Child Protective Service. So what was facts and now is Department of Community and Justice. So my understanding is under the relevant legislation, Department of Community and Justice actually has quite broad powers to subpoena clinical records. Apart from subpoenas, might there be other sort of legal issues that come up where people ask for records, and what obligations do clinicians have under those requests?
Well, it's a very complex area. I mean, if you receive a request from the police or from another government organisation who is charged to, take care of people under guardianship or children, it depends on what their power is in terms of their request. I mean, obviously, if it relates to the welfare of a child, I think the answer is a simple one. You obviously would help in that situation by disclosing the information. But with any request, I'd make sure that you get that in writing, and you ask for the specific authority under which they have sought that information. So that way you're covered in the event that you can say, well, if there is an issue about that, later down the track, you can point to the letter and indicate, well, I complied as this person was obliged to or had the authority to request the information from me. But in terms of any request that requires a volunteering of the information, which is relevant to a court matter or a civil matter or anything related to, because we deal with gambling and all of our issues arise from gambling, the consent of the client would also be required. So consent, if you don't get that, then that becomes an issue, and the requesting authority needs to get a formal court order for the release of those documents.
So, okay, thank you for that. And yeah, so I guess, another good point that you bring out is just make sure you get everything in writing. So,
yes, absolutely.
Especially these days, I've noticed that particularly probation and parole have since COVID have been quite lax in getting things in writing because they're not doing face-to-face appointments anymore. So we're getting more phone requests for things, and I've been telling them, well, you're not getting anything until you give us something in writing, and they sort of drag their feet a bit. But just to protect yourself, I think that's a really crucial thing, is just to get everything in writing and document anything that you do. Not just as Shayla was talking specifically about what you're doing in session, but also it's really important to document anything that goes around a client. So, phone calls you get from other parties, things like that. Okay. And yeah, Shayla's just pointed out as well that for those of you that are psychologists at the APS, if you remember, can provide assistance for legal questions as well. And I'm sure those of you who are registered with other professional bodies, such as counsellor associations and social work, they also have equivalent peak bodies that may also be able to give you advice. So just one last question. I guess this one probably is for Shayla. If the client requests not to record their symptoms on diagnosis on a report, what happens if I leave my position? The new counsellor will miss out on this information to provide the client's treatment. Can that be considered negligence of care? Yeah,
potentially. Right. I mean, that's pretty important information. I mean, there's a whole big, that's not so much, it depends. It's more, there's a whole, whole process that happens before we, record in the note. So that's all the bits that we don't know in terms of what are their concerns about recording it. Is it actually part of the presenting problem in terms of how they access and utilise, treatment? What would be the duty of care to them, to other people involved with them? So yes, potentially by withholding that information, it will have implications. I think it's I do think it's a duty of care issue, definitely.
Okay. Well, thank you for that, Shayla. And unfortunately, that is all the time we have for today. So I'd like to give a big thanks to our two panelists, Shayla and Dragan, today. And thank you both very much for your time and your preparation work, and for completing the slides that, as I said, what I'll do is once we have the recording finished for today, which probably will come out probably tomorrow or early next week, I'll send the slides along with the recordings for those of you who have attended today. So thank you very much to our panelists. Thank you very much to everyone who attended. So just a reminder, our next two journal clubs will be, so the next one will be on the 15th of April, which will be on being an effective ambassador for the gambling sector. And then we have a final one for this half of the year, which will be on the 3rd of June, which will be a face-to-face session with webinar components for those of you who cannot make it to uni. And that will be, I guess, sort of sharing stories, sort of format, which we've tried before in the past and has gone really well. Guess just as sort of a way of, you know, transitioning from, you know, I guess we still have question marks about what the sector is going to look like after June. So I guess it's sort of a way to sort of have a meet with people that we've been working with for a long time to sort of, yeah, see what's going to happen in the future. So that's going to be on the 3rd of June. And if you have any other questions, feel free to email me and I will get back to you as soon as I can. And yeah, so I know some of you have already sent me emails asking for the slides. So yes, I will send them out once we have the recording ready to be sent out in the next few days. So, okay, big thanks to everyone and I will see you soon.
Thank you, Chris.
Thank you.
Bye.
Thank you, Chris.